So, a little temperature testing here. You enjoying the day? Yay! Excellent. We've had some great speakers and more to come. I did want to let you know that we do have vouchers for discounted parking if you self-parked at 5th and Marshall at the garage there. So if you need a voucher for discounted parking, you can get that at our registration desk. All right? So, with that said, it is now my pleasure to introduce a familiar face to many of you. Jay Douglas has been the Executive Director of the Virginia Board of Nursing since 2002. In this position, she oversees the licensing and disciplining of more than 216,000 licensees and certificate and registration holders, including registered nurses, licensed practical nurses, advanced practice nurses, massage therapists, nurse aides, and medication aides. Prior to assuming her current position, she has served as Deputy Executive Director for Discipline at the Board of Nursing for 3.5 years. And immediately prior to the Board of Nursing, Jay served in a variety of roles, including Administrator for MedShare's Home Care from 1994 to 1999. She is a registered nurse with a master's degree in management, holds a certification in substance abuse counseling, and is a fellow of the National Council of State Boards of Nursing Institute of Regulatory Excellence. Jay will be speaking to us all about criminal background checks, the Enhanced Nurse Licensure Compact, and continued competency requirements. We've saved some time for Q&A at the end of her presentation, so we ask that you hold your questions until then. And Jay, thank you so much for joining us.
Hello. Don't worry, I wasn't checking my email. I had to get my clock so I knew what time it was. What time it was here. So, welcome. It's been a great day so far, and I'm pleased to talk to you about 3 current topics with the Board of Nursing. There's certainly a lot I could talk about. I'm certainly open to questions at the end. Before I get started, I just want to recognize 2 people associated with the board, and one is Florence Jones Clark in the back there, is former president of the VNA, as you know, and is a former board member. So welcome, Florence. And Jody Power, Deputy Executive Director for the Board of Nursing. Jody reminded me the other day that she's been working at the Board of Nursing for 20 years. I know she doesn't look that old, but, you know, and she was with the department before then, so. As I'm making my comments today, I just wanted to ground you in what is the mission of the board, you know, to assure the safe and competent practice of nursing, to protect the health and welfare of the citizens of the Commonwealth. And I think that's important to remember, whether it's a decision a board makes about an individual case, whether it's a regulatory matter or any legislation that the board might recommend be put forth. The board always has to look at protection of the public, as that is their mission. I'm going to start today with the first C that has to do with criminal background checks, and it is the latest initiative with the Board of Nursing. And the criminal background checks came about because of legislation that was passed at the last year's General Assembly, so you heard a lot about that at the time. And you can see in the code, and I think as I talk about the 3 things today, criminal background checks, the compact, and continued competence, we have 2 examples of legislation that affected nursing in Virginia, and one of regulatory activity that resulted in a requirement related to licensure. So obviously the legislative issues are things that come before the General Assembly and have to be approved by the legislature to become part of the Code of Virginia. So in the Code of Virginia currently there is a requirement that all applicants for licensure, for RN and LPN licensure, now are required to have a state and national fingerprint criminal background check. And this is the section of the code that it's in. You know, why criminal background checks? As you all know, we deal with the most vulnerable of people. We are, in many situations, whether it's in facilities or people's homes, entrusted with, you know, belongings and finances and property related to patients, and the character and of a nurse is very important in making a decision for the board to issue a license that gives that kind of authority. These fingerprint background checks are reliable. They offer some some objective data as to a person's history that helps the board in making a licensure decision. So who is currently having these criminal background checks starting January 1, 2016? RNs and LPNs who are applying for licensure by examination. So students that are out here in the audience today, when you come to applying for licensure by exam, this will be part of the requirement. It applies to individuals who are being licensed by endorsement, somebody who's licensed in another state and coming to Virginia, whether they've had a criminal background check or not in that prior state, they're required to have one here. For initial applicants who are applying following reinstatement of their license, so they may have lost their license due to suspension or revocation, or let it expire for so long that they actually had to apply again for reinstatement. I'll probably say this several times today, but the criminal background check, or CBC requirement, and I know that's a strange term for us nurses to hear because we don't think of a criminal background check when we think about CBCs, but we had to have some abbreviation to deal with at the board, and actually nationally with boards of nursing, they're referred to as CBCs. So there's a little bit of confusion for us, initially. But remember that a criminal background check is not required to renew your nursing license. This does not apply to renewal. And some would ask, why not? And, it's a starting place to do a criminal background check upon initially issuing a license. And the board did not seek legislative authority to do it upon renewal because not many states are doing that at this point. We'd like to see what the experience is with other states. And eventually there will be a system where if you have had a criminal background check run, there will be a federal wrap-back system that will, once you are in the system, will then send results to the board if someone has a subsequent conviction. So we're going to see how long it takes in Virginia for that to be rolled out. It's not something in control of the board, obviously. And we'll start with initial criminal background checks and see how that goes. So I've already had lots of calls about people who think that they need to do it upon renewal, and we've even had some people show up at Fieldprint, which is the vendor that does the criminal background checks, to get their renewal criminal background check done, and it is not necessary, so please share that. So I just want to talk about when you're completing the Virginia Board of Nursing licensure application. And so I'm speaking to a lot of the students in the room, a lot of the faculty, or as you're talking to your employers. People are required to disclose any convictions on the actual application for licensure. There's questions related to that. You're not required to disclose arrests if you're not convicted, and no further action resulted from the arrest, but you are asked to disclose those things. So what happens with the results? You apply for licensure, you go to our one of our vendors around the state, and I'll talk in a minute a little bit more about that. You get the criminal background check done, and the results are reviewed by the board once we get that back. So the board has an application that's been filled out. As you've answered the questions, we have the criminal background check results that come in, and we're also looking to see if someone's had a prior application in a different occupation to see what were the responses to those questions on those applications. So after the application's been received and people then have the criminal background check, they're notified of the outcome of that by letter. If an individual's record reveals no convictions, then the process moves forward normally, and there's very little delay. We've been glad to realize, which was the plan, that when you have a criminal background check and you have no record, the Virginia State Police is informing us of that very quickly. We do a daily electronic download, and so there is really no change in the process or no delay to the licensure application if somebody does not have a criminal record. However, if somebody does have a criminal record, they may meet the criteria in the law where there is grounds for denial or restriction of a license. The statute that allowed the board to authorize the board to do criminal background checks did not change the kind of convictions that the board looks at or any of that authority. There are no absolute bars to licensure. But if the conviction that somebody has had relates to the code that's already in place, there may be cause for denial. Then that individual's application will then go into what we call a non-routine application process. So it certainly does require another level of review. That may be a review by myself or one of the deputies. It may be somebody would have to appear before the board, but there's a non-routine process. Certainly the board has always looked at, and does under this program, looks at the age of convictions. What is the conviction for? Has there been a change in circumstances since the conviction? So all those factors are taken into consideration. We certainly see a lot of applications where individuals have had misdemeanors related to things that they have done as youth, and it's now 10 and 15 years later and things are quite different. So the board does take all those things into consideration. However, if an individual has not revealed on their application for licensure that they've had any convictions, but when we run the criminal background check, it shows there's convictions, that is a problem, because that certainly can be interpreted as falsification of application for licensure. And so an individual might then have to deal with their conviction issue and the falsification of the licensure application. So, as I was referencing before, what's currently in the Code of Virginia, and this was not new, this has been here for years, the statutory guidelines that we have to use when looking at convictions are in 54.1, 3007 of the Code, and it addresses a conviction of any felony or misdemeanor for involving moral turpitude. And for us, the definition of that is the lying, cheating, and stealing types of convictions is what the board has authority to act on, or convictions that might indicate a possible impairment related to drug or alcohol use. That could be looked at as well. And when we get conviction records or we get responses to applications that indicate positive, that somebody has a conviction, we're also asking for the individual for an explanation of that situation. So we also have, even as part of the online application process, is the ability for an individual to say, yes, I had this DUI conviction, 10 years ago, and I was young and, went to a party and shouldn't have driven, and I did. And, so there's a chance for the individual to provide some information that helps the board in their decision-making as they look at these types of applications. We're also looking at, did the person disclose or not on previous applications the same conviction? Because if you just, you apply for licensure by examination and you say you had a conviction for theft 4 years prior when you were a CNA, you said it was 4 years prior, but when 4 years prior you had a certificate as a CNA and you didn't reveal that on that application, then that's something else that the board might have to look at. So as you can see, it's become a complicated review process, always has been in terms of convictions, and now we have the objective data from the criminal background checks. And we have been collecting data for several years on the types of convictions and what the board does as a result of that. So the processes have not changed for review of non-routine applications. The new thing is that there is this objective record that's now obtained through the fingerprint process. So each application, as I said, is considered on a case-by-case basis. There are no absolute bars to obtaining a license. There are no convictions that are an absolute bar to obtaining a license. There are in some states, but not in Virginia. So if the convictions falls under one of these type of convictions that's in the statute, then the board on a case-by-case basis will gather all the information and make a determination, based on age of the crime, nature of the conviction, that kind of thing, as to go forward. There's 2 documents that are important for you to remember that are out there, and I would encourage you to share these with people. They're guidance documents that are on our website, and one has to do with the process we use for non-routine applications, and the other has to do with a joint guidance document with the Department of Health that looks at employment and convictions and how convictions can affect employment. So I encourage you to take a look at those. There are also some frequently asked questions on the website, and but just to give you a snapshot of the statistics we have found so far, And as you can see, January 1 was the kickoff date, but that was a holiday. So January 4th was the first time we really started having anybody have criminal background checks run. There's been 620 total transactions since then, from January 4th to February 12th. As you can tell, that's a busy time of year for us in terms of applications, and that is why when you apply to the board, things might not be turned around as quickly as if you apply in a different month. 365 of those individuals had no records, so there was no convictions. 84 of the transactions are still being processed, so they could be possible or confirmed. When an individual goes to, we have an outside vendor that does the criminal background checks. It's a company called Fieldprint, and an individual can go through a web-based scheduling application. 24 hours a day, they can schedule their appointment to have their criminal background check done. And by putting in their zip code, they can identify the location of one of the 22 sites throughout Virginia. Now, we only have 7 NCLEX sites in Virginia, but we have 22 criminal background check sites. So we were really pleased that we were able to get a vendor that could provide that kind of access. And so when you put in your zip code, you not only get the closest location, you get a picture of the location, you get written directions there, and you get all kinds of information, and you can go on and actually schedule your appointment at a time that's convenient for you. So easy access. But once that fingerprint is done, actually collected, it is transmitted electronically to the state police. And the state police is the entity that has authorization to interpret and run those records. And so the state police then is able to send a report to us that says no convictions, or if it's a yes, they have to do the research behind that to really identify what were the convictions and when did they occur. And then they send us a report. They send us the actual. This is Virginia, so they don't come to us electronically. They come hard copy in the mail, so we had to put in place a very secure kind of mail system with nobody else open these envelopes that look like this from the state police, and then we go through the hard copies and see what we have in relation to what the individual has disclosed. And the whole thing of, the snail mail and the hard copy conviction records is not within our control. Unfortunately, it's within Virginia State Police, so we look forward to the day when that will be more of an electronic transaction. And there is a team, with this legislation, the Board of Nursing was given 2 additional positions. So we have 2 staff people that have joined us that have extensive background, have both worked in criminal background check units and are doing a fabulous job, and a deputy for licensure position that is a new position, but only 50% of her time addresses this criminal background check unit. So they're experienced, they're working out all the kinks. As with any new thing, we will probably change some processes as we go along and see what works the best. As you can see, 3 of the active results included rejected fingerprints, and you will get a rejected fingerprint. I have to tell you, I had to have mine done for something last year, and they said to me, "Oh, you're probably going to have to come back because you don't have enough little ridges on your fingers, and I think this is going to reject, and you're going to have to come back." And I was like, "Oh no." Well, that's going to happen to some of our licensees, and if that happens, we do it again, and then we continue to work with the individual. It may be that it's just not possible, so we have some policies that address that. The criminal background check results are good for 90 days from the date we received the results, and that's how we're going to work for that. So if for some reason somebody's application doesn't get completed because they didn't, submit what they needed or whatever, it may run out after 90 days, but 90 days is the period of time the board's decided they would be valid. But I think very interesting here to look at that so far, now this is just January 4th to February 12th, 15% of the applicants checked no to the question about convictions and then were later found to have a conviction. I don't know how that, a very small percentage of those people checked the wrong box, but my colleagues in other states tell me they have similar percentages. And so I don't know if people think, well, they won't find out. I don't know what they're thinking, but of course, those individuals now have a bigger issue to deal with. So it is a whole new program that we are moving forward on. We'll have more to report as time goes on, and we'll certainly have some data to compare to self-disclosed and actual results that we find. New initiative. We're so far very pleased. It's taken a lot of work with the state police and a lot of work on the technology side of things to get this up and running. And we appreciated, V&A's support in being involved in this initiative when we were coming to the General Assembly last year, because we came to the General Assembly as a result of a need related to the Nurse Licensure Compact. And as I talk about the compact, you'll see where, because of the work that was done last year legislatively, we didn't have as many hurdles this year with the new model of the Nurse Licensure Compact. So let's just talk about the compact. I was checking my time and see Shirley Gibson sending me a photograph somebody took of both of us. It just popped up on my phone. So let's talk a minute, before I talk about the Nurse Licensure Compact, about how an interstate compact works. And you need to know that Virginia belongs to many compacts. There's more than 20 compacts Virginia belongs to, and it's not the Board of Nursing belonging to the compact, it's the state of Virginia belonging to the compact. And so a lot of the language that's in the current compact and in this new enhanced version of the compact is language that's in other compacts related to how the organizational structure works. So each state has to enact an identical compact. In the current one we're in, there's 25 states that enacted that. Virginia enacted the current compact in 2005. It's a mutual recognition model of licensure, which is outlined in the compact, kind of similar to the driver's license compact, where, when I drive to South Carolina recognizes my driver's license, and they don't make me stop at the border and get another license. That's really the concept of mutual recognition. So for the Nurse Licensure Compact, important to remember that it's a state-based licensure model. The state is still in control of this. You have an agreement between states on some mutually agreed upon circumstances of how we interact. So it's a state-based license, one license. An individual holds one license in the state in which they reside. It is nationally recognized, so it's recognized by all the states that belong to the Nurse Licensure Compact, but it's locally enforced. Locally enforced meaning that if a nurse from another state is practicing in Virginia and there's an issue with her practice, the Virginia board can address that and can act on the multi-state privilege or enforce their laws and regulations, because a nurse is required to follow the laws and regulations in the state in which she practices in the compact. So it's locally enforced, and licenses, of course, are issued by the state in which the individual resides. So that's the model of the current compact. It's the same model of the proposed enhanced compact. And I think it's important to remember the benefits of the Nurse Licensure Compact. It gives states the ability to share complaint and investigative information. I'm sure there's some of you in here who have had times when you've had to address problems with individuals. I think the one that's, from a public safety standpoint, that's probably the most concerning is when you have a drug diversion, or you have somebody you suspect of a drug diversion, and you do this thorough investigation and you start addressing it, and they just resign and leave. Sometimes to another state, sometimes to another, employer. So through the mandatory reporting laws that we currently have for health systems in Virginia, that type of investigation is reported to us, and we start working on that. The individual hops to another state. I can share with the other compact state that we have an investigation going on, and the compact actually prevents a new state from issuing a license until that investigation has been taken care of. So there really is a lot of protection of the public there. There's shared responsibilities for patient safety not governed by geographical boundaries. And many of you that live within the borders of Virginia know that there's the ability, and in practice, nurses practice across borders all day long, so it certainly does enhance that ability with all the states working together. And through the multi-state privilege that a nurse is afforded, states can act on and issues that relate to practice when somebody is not practicing in their home state, but they're practicing somewhere else. This just gives you a visual of how many states are currently in the compact and where they are located. And so the blue states, people that are in the nurse licensure compact, Montana just joined this year. 25 states, and I'm going to talk in a minute how we want to move forward and have more states in the compact. So I think I've really touched on this, the one license in the primary state of residence to enhance public protection, to ensure that the state licensing authority has the authority over that, and reducing administrative burden by individuals who have to have licenses in multiple places. I had a situation this week when I was talking to a nurse who actually does not reside in a compact state and has moved around a lot through travel assignments, and she actually holds licenses in 40 different states because she lives in a non-compact state. So to practice even in compact states, she has to, you've got to live in a compact state to have a license with multi-state privilege. So if you live in a non-compact state and you want to practice in a state like Virginia, North Carolina, South Carolina, you have to apply for a license. And she has 40 licenses. So it certainly reduces the administrative burden for boards and the cost for an individual like that, and gives her the flexibility to practice within those states. So Andrew Lamar talked earlier about the Nurse Licensure Compact Bill, which is Senate Bill 265, and let me just say how proud I am and pleased with the collaboration between the Virginia Nurses Association and the Board of Nursing around this bill. You know, we at the board, both staff and board members, are in a situation where the board might want to advance legislation, might want to move something forward, but we can only have a position on something if it's the same position as the governor. And fortunately, the governor the board proposed to move to a different model with the Nurse Licensure Compact, an enhanced model, and the board proposed legislation that was moved through the agency to the governor as a recommendation, and the governor put that bill in his packet. So it gave us the opportunity to not have to, you know, often I'm at the General Assembly and I have to say we have no position, or, you know, I'm neutral on this because the governor doesn't have a position, or the governor hasn't given us permission to say what the position is. So fortunately with this bill, it was very clear this was a governor's bill. The governor was totally supportive. So as we've worked through the legislative process, both the association can say whatever they want, but I can't always. But I was able to say, you know, that the governor is in support of this bill, and this is why, you know, I was able to do a lot of education through the legislative process, which really was very helpful. And the collaboration that occurred between the Virginia Nurse Association and the board on this was terrific. As we met with legislators individually, and then we had some joint meetings with legislators. We came together and said, what's the message going to be about this bill? We all were speaking the same message, and I think it was very powerful. There's several meetings with Andrew, Kevin Shimp, Janet, and myself, and it was very powerful. You know, I could speak from the standpoint of this is how the compact works, and this is why we want to try and introduce a new model to get more states involved, and VNA members and from the employer perspective too, were able to say, you know, this is what we like about the compact, and this is, you know, why we want to stay in the compact, because this bill is really about Virginia staying in the Nurse Licensure Compact. So I think that was a really good example of us working together. The administration, in their wisdom, identified a patron who was a nurse, Rosalind Dance, and she was the patron for this piece of legislation, and that relationship was very open and collaborative, and she was very clear on, you know how all this works more than I do. I'll speak to it, but you better be there in case I have questions or I want you to say something. So it really did work very well. So Senate Bill 265 is about Virginia staying in the Nurse Licensure Compact. I'll reduce 2 years of work down to a couple of seconds in that all boards of nursing across the country got together and talked about, why do we only have 24 states in the compact? At the time it was only 24. What are the barriers? What are the concerns of the states that are not in the compact? We actually had a facilitated process through somebody from the School of Public Health at Harvard that facilitated discussion between the boards of working through the obstacles for some states joining. And there are many different, it's very individual. We have our Virginia way, and every other state has their way. And so it may be that a nursing association wasn't supportive, it may be a union issue, it may be there's one legislator that just doesn't like compacts, whatever. So we kind of worked through that, but what it really came down to for nurse regulators was that when you're in the compact, each state issues a license with multi-state privilege. But in the code that related to the compact, as compact states, we weren't all held to the same requirements to issue a license with multi-state privilege. So I would make my decision based on Virginia state law, North Carolina would make their decision, and their state law might be a little different. But we were all issuing a license that let a nurse practice in all 24 states. So some of the states that had issues said, why would I want a nurse from a state practicing in my state on a multi-state privilege when you that issued the license don't require the same things I do? And the good example that held true for many years was the criminal background check piece. Why would the Kansas Board of Nursing, who's been doing criminal background checks for years, think of joining the compact when it would allow a nurse from Virginia who'd never had one to practice there? So all that to say, we came up with 11 uniform licensure requirements, meaning that all these criteria have to be met before a home state in the compact can issue a license with multi-state privilege for an individual. And I'll probably say this twice, but that doesn't mean that if somebody applies that doesn't meet all 11, I can't give them a license, but I have to issue them a license that was good in Virginia, valid in Virginia only. So these are the 11 things. And I'm pleased to say that really, essentially, the two in red are the only two things that Virginia does not do at this time. So Senate Bill 265 is the model language that will be introduced in all states that want to join the enhanced version of the Nurse Licensure Compact. The bill looks the same, the language looks the same. And the uniform licensure requirements for issuing a license with multi-state privilege are, one, that it meets the home state requirements, that they've graduated from a board-approved nursing education program. That's true for Virginia right now. That a foreign educated nursing education program has been approved by an authorized entity that has expertise in credential review. So for those of you who've been around a while, in Virginia, we use the COGFINS or CGNFS as the entity that has to review when somebody applies for licensure in Virginia, if they've graduated from a foreign education program, the credentials have to be reviewed by that entity to see do they meet similar requirements as Virginia. So we've always done that. That's not new for us. But there are some states, for example, California, where the Board of Nursing staff review all those applications and determine themselves if there's education equivalency. And I'm glad that Virginia has relied on an expert outside resource to do that for us, because when you look at the countries that we have people apply from, you have Ethiopia and the Philippines, and we've got people coming from all over the world. You need a group that has expertise in credentials to evaluate equivalency. So we already do that. A proof of English proficiency if somebody is educated in a foreign education program and English was not their primary language nor the language in which they might have been educated. Passage of the NCLEX, which is obviously required in Virginia. In order to have a multi-state license, you have to have an active license. You would have, if you have an active license from somewhere else and you're coming in by endorsement, one that is not disciplined. The biometric background checks, which now we have in code. This is the one where there is a change, no felony or no misdemeanor related to practice. So right now, somebody having a felony conviction or a misdemeanor that's related to practice, that's not a bar to licensure. The board could issue a license based on that case-by-case review I was talking about earlier and looking at all the circumstances. But if an individual with a felony or misdemeanor related to nursing practice wants a license applies for a license with multi-state privilege, under the compact, we could not issue that. I would have to issue them a license valid in Virginia only if they wanted a license in Virginia. 9 is that they're not in an alternative program. For Virginia, that's the Health Practitioners Monitoring Program. We already in Virginia limit practice for somebody who is in that program to practice in Virginia. That's done currently via an agreement and with the contract with the program. So that's not a real change for us. And there is a self-disclosure requirement that on the questions when applying for a license with multi-state privilege, they would have to tell us if they were in a program in another state related to impairment. And then 11, a valid U.S. Social Security number, and that's not currently a Virginia requirement. You can apply using a Social Security number or a DMV control number. So if an individual wanted a license with multi-state privilege, they would have to provide that Social Security number if they had one and didn't want to provide it, or if they didn't have one yet, they would get a license that was valid in Virginia only. So we're calling this new model of the compact the enhanced version because most things have not changed. The things I'm referencing for you are the things that are new. And the other things that are included in this enhanced version of the compact is a grandfathering provision, and Andrew referenced this earlier. So if you hold, as of now, a license with multi-state privilege, when this new compact goes into effect, you still would have a license with multi-state privilege as long as you don't let it lapse or you move out of state and want to come back in. Because if you let it lapse or you move somewhere else and come back in, you'd have to meet the new requirements. It also includes the oversight by the Interstate Commission of the Nurse Licensure Compact. This is the governing body of the Nurse Licensure Compact, which already exists in the form of the Nurse Licensure Compact Administrator Group. So each state has one person that sits on the commission and currently sits on the NLCA group, and we establish policy and look at oversight and compliance with the compact, and I serve on that group currently. So in this new version of the compact, it's renamed the Interstate Commission, and there is some authority for making regulation, rulemaking related to how the compact operates only. And the enhanced NLC also addresses compliance by member states. So if you've got 25 or more states in this agreement, you want to make sure that everybody's complying with and doing things consistently. And so the statutory language that's in this bill addresses compliance with the Nurse Licensure Compact. So when might this go into effect? And this is the piece that, as we talked about this bill, there was a little bit of confusion with the legislators, but obviously we got it straight because so far anyway, we haven't got to the other side yet. So far we've got it straight. The compact will not become effective until the earlier of two dates. Either 26 states have passed this new language, the enhanced version of the compact, or December 31st, 2018, whichever comes first. So whichever comes first, then the new compact will go into effect with the states that have passed this new model. So that could be some of the current ones I had up on the map and some new ones. It could be all of the current ones and some new ones. We'll see where that goes. We do know that as of today, there's about 15 other states that are working through their legislative process on this new model, and I'm really pleased to say that several of those states are states that have never been in the Nurse Licensure Compact before. So what we set out to do really has been accomplished in that we've taken care of some of the states' problems with the compact. So states like Florida and Wyoming are moving forward. West Virginia RN, Oklahoma, and they were states that were not in the compact before. Now they have to go through their legislative process, but they've started that initiative. And as the effective date is December 31st, 2018, or 26 states, whichever comes first, it gives an opportunity for people to work on this next year if they have some, issues this year. So, if 26 states join, as an example, by January 1st, 2017, the compact becomes effective, and if 20 states have joined by only 20 have joined by December 31st, the compact becomes effective. So there may be a period of time, we'll see what happens, and hopefully we're in the front end in the new batch. South Dakota has already been through the Senate and the House. They got the #1 award for making it through the legislative process, but we may have a period of time when there's two compacts, but we will continue to work through any questions or issues related to that. And multi-state licenses then issued under the prior compact will still be recognized for 6 months after the effective date. So it allows, the bill allows for some transition with this new compact. So just included there for you, and I'll certainly make this available through VNA, the presentation. There are some contact points there that you might want to look at, some opportunities to get some email updates. National Council has become very involved and across the nation with helping states who are wanting to move forward with this nurse licensure compact, and we have some expert legal counsel help from the Council of State Governments who are the specialists in compacts. One of the things we were worried about as we move forward with this legislation was a lot of people don't understand compact law and how it works. And I learned through this process from our legal counsel there's only one law school in the country that includes a special course focused on compact law, and that's the Lewis and Clark Law School out of Oregon. So we know that we have legislators, we have people in the Attorney General's office, we have attorneys, we have a lot of people who don't understand compacts. So that's some of the work we've had to do as we've talked to people about what is this compact. Because as I said before, Virginia already belongs to about 22 compacts, and this is just one example of them. So I'm going to move along to continued competence and then give you a chance for some questions. So the continued competence regulations went into effect in August 2013. This is an example, once again, a great collaborative effort, but the first two things I've talked about are things that were legislative changes. This is a regulatory change. It started out with an initiative where somebody wanted to require in the Code of Virginia that a nurse had a certain number of CEU hours to renew their license. And a lot of people in this room that had a lot of wisdom about it, VNA folks and the Hospital Association, the Virginia Organization of Nurse Executive Leaders got together and talked and said, do we really want something like this in the code? And we're not convinced that CE demonstrate competence anyway. The research hasn't been finalized. There is no, what we've got here is just a beginning. There is no good answer to this. This is just a beginning, but certainly aware that if there's going to be a requirement for nurses to have continued competency requirements for licensure renewal, it would be better served to be in regulation that can be changed more easily than to be in the code. Now, I say that, it's because it's a lengthy process for reg change here, but it is easier than in the legislature. So, AARP was instrumental in coming forward and pointing out to the profession that nursing was the only health profession left that did not have any continued competency requirements for licensure renewal. And that is true. All the professions at the Department of Health Professions have requirements. The CNAs do, the med aides do, the physicians do, everybody does. Nurses didn't. So we do now, and those regs are fully in effect. And so anybody that started renewing their license August 2015 or beyond, so who renewed your license after August 2015? Okay, so you had to answer, you had to attest to the fact that you'd met those continued competency requirements and could be subject to some kind of audit at a later time. So the board developed a committee, got a lot of stakeholder input on this. As I said, we know that it's not the best, but we tried to give options for people. so that these continued competency regulations don't just address the nurse at the clinical bedside. They can be applied to a case manager, to a nurse regulator like myself, to a faculty member, to whatever. So there's 9 options. And I get lots of calls from people who say, oh, no, but you don't understand. I don't have this. I'm not at the bedside. Well, trust me, there's an option in here that you can meet. And the other thing I will say as I'm talking about this is please talk to your colleagues and think about, as you're renewing your license, to pay attention to the statements that are relative to nursing practice. And this is not a joke. I get nurses, I'm kind of embarrassed to get these calls, but we get calls from nurses who want to use things like a dog therapy class they've taken or something like that. And I'm like, this is about you renewing your professional license and providing evidence to demonstrate competency to continue the practice of nursing. If you don't know what the practice of nursing is, we got a problem. Now, I can't say it quite like that, but I'm telling you, we get calls all the time. So there are 9 options allowing for varied practice settings, and I'll just quickly move through these. You may have a current specialty certification in nursing, completion of a 3-credit hour of post-licensure academic education, or a board-approved refresher course, or completion of nursing-related evidence-based practice project or research study, or the completion of a publication as an author or co-author, teaching a course or a continuing education course, 15 hours of CEU relevant to nursing practice with 640 hours of active practice. So this is really the one that a lot of people choose because they're working currently in nursing, and so their active practice hours plus the CE combination is the option they choose. But it was very purposeful on the part of the board not to require people to do things that were duplicative of what their employer was already requiring them. I mean, if you're working, at the University of Virginia Health System, Bon Secours, VCU, and you're doing all the things you're doing for your ongoing competencies, and then you can use those things. It was not meant to increase the financial burden. But you've got to remember, as with any regulation, and this is something to think about when we pass poor legislation or we develop regulations that are going down a weird trail, a regulation has to apply to apples and oranges. The nurse manager in an acute medical setting and the nurse that works in a solo physician's practice that never intersects with another nursing professional and doesn't have any access to anything. So to ensure that we address all those individuals in practice settings. And the last option is 30 contact hours relevant to the practice of nursing. So just know that in the regulations, it's very clear as to what evidence you need to keep to show that you've done these particular activities. And it's also clear in the regulations what entities have to have approved the educational offerings that you undertake. So they have to be approved or offered by an entity, but it does allow for the educational activities to have been offered by an employer, a hospital setting, and the circumstances are specified. Please, please, please do not fax or email things that you want us to take a look at to see if it's approved. We are not in the business of approving CE or approving those courses. Your job as a licensee is to go to the regulations and say, this is what I want to do. Does it meet one of these 9 options? And is it offered by one of the entities that's in the regulations? There are also very detailed FAQs on the website that you can access about that. And I think I've actually covered most of the rest of this. Maintain your documentation for 2 years after your renewal cycle in case you are audited. Don't submit anything upon renewal. You're attesting, do you meet it? And when you're audited, then you'll have to provide that information. So, the 3 C's: continued competence, criminal background checks, and the compact. And I'm happy to answer any questions you might have briefly before Janet kicks me off the stage. So, I see somebody coming.
Jay, for the graduates, or the graduating students here. If they don't take their boards within that 90-day period from the time they get their fingerprints done, or from the time you get the result, first of all?
Okay. There's a couple of 90 days we probably need to talk about so they don't get confused. First of all, a new graduate that's wanting to practice as an applicant can only practice for 90 days from the date of graduation. So if somebody, that has nothing to do with the criminal background checks that's been in effect forever. So if somebody graduates in December but doesn't apply till January, and then we have to authorize them to test and authorize you to practice, you've eaten up 30 days of those 90 days, so don't forget that. And that letter that's the authorization to test letter or authorization to practice is what you give an employer. It's the equivalent of a license, if you will. It's the authorization to practice. The criminal background checks are good for 90 days from the date we receive the criminal background check results. You cannot get your criminal background check done until you have applied for a license, because when you apply and pay the fee, then you get the code that you can use with the vendor so you can actually get it. And individuals go to the vendor, they pay the fee for the criminal background checks, which is $46.50 or something close to that, and that's paid separately to the vendor, not to the board. But make sure you've applied before you go and try and get the criminal background check. You apply first. Yes?
And that background check is good for 90 days. You have to take your NCLEX for 90 days.
Say that again?
Do they have to take the NCLEX within those 90 days?
The 90 days has nothing to do with taking the NCLEX. An individual applies, they cannot be authorized to test until the board has authorized you to test. Once you get that letter, that gives them the authorization to practice, but they can't practice more than 90 days from the date of graduation. The criminal background check results are good for 90 days from the date we receive the results. So my point is, let's say you apply, you have the criminal background check done. For whatever reason, the board is asking you for some documentation related to your application, and you take longer than 90 days from the date, you look on your checklist and you see we've got the criminal background checks, but you take 120 days, then when we're finally acting on the application to issue a license, you may be required to go and get that criminal background check done again. Because the board wants to make sure that, you're giving people a period of time, but to make sure nothing has occurred in between. Because I can tell you, and Jody can certainly back me up, people get convictions while they're in nursing school. Unfortunately, that happens. And so the board, in making a decision then to issue a license, wants to make sure, okay, from the time you applied and the time we issued it to you, are you in good standing? Any other questions? All right, good. Thank you.